Hey all, my name is Jessica and I'm with Key HR. We are a boutique company that helps small business owners solve HR issues. Usually when people think of us, they think we just do payroll or benefit administration, or they think we're just another PEO. We are the real deal. We are locally owned, women-owned, and small business right here in downtown Orlando. We have a fully staffed HR department with SHRM certified professionals available to help our clients stay on top of the daily challenges in our industry. That being said, I've had a lot of questions come in from local business owners in the Central Florida area. Due to the type of business we are, we receive all the latest updates and resources available for business owners with regard to the COVID-19. The truth is, it would be a terrible waste for me to only share this information with my existing clients. So I've created these videos as my social distancing way to help educate the community and provide the resources that are available to them, with the hope that I'm able to make a difference and help as many business and owners out there as possible improve our local economy here as a whole. So just a quick copyright statement. Under the Copyright Section 107 of the Copyright Act of 1976, allowance is made for fair use for the purposes of criticism, comment, new reporting, teaching, scholarship, and research. Fair use is permitted by the copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use. We can all win this together. Now on to today's topic. Today's topic is the Families First Coronavirus Response Act, which was recently passed this week. On Wednesday, March 18, 2020, the Families First Coronavirus Response Act was passed by the U.S. House of Representatives earlier this week. The FFCRA implements many changes to increase public health measures. The FFCRA temporarily requires most U.S. private employers to provide paid leave to employees for certain COVID-19 related reasons and expands the Family Medical Leave Act to provide employees paid leave under FMLA to care for a child as a result of school or child care closing due to public health emergency. While employers are responsible for the funding of the paid leave, employers will be able to take tax credits for the paid leave provided to their employees under the FFCRA. According to the U.S. Department of Labor, the paid leave provisions of the FFCRA will take effect on April 1st, 2020 and expire as soon as December 31st of 2020. The FFCRA applies to most private employers with less than 500 employees and private employers and public employers with at least one employee. For the purposes of employer coverage calculation, the Department of Labor advises that employers should count all active employees, full and part-time, as well as employees on leave, temporarily employees who are jointly employed with another employer, day laborers supplied by a temporary agency, and independent contractors do not need to be included in the employer coverage calculation. The Emergency Paid Sick Leave Act requires covered employers to provide 2 weeks of paid sick leave if an employee is unable to work or telework due to a need for leave because the employee is subject to federal, state, or local quarantine or isolation order, has been advised by their healthcare provider to self-quarantine, has experienced symptoms of the COVID-19, is caring for an individual who is subject to one of the above orders, or is caring for a son or daughter because their school or place of care has been closed, or they are experiencing some type of substantially similar condition. Full-time employees are entitled to 80 hours of paid leave for the reasons listed above, and part-time employees are entitled to paid leave up to the average number of hours they've worked in a 2-week period for the reasons listed above. Once the 80-hour entitlement is exhausted, no additional leave under the PSLA is available, even if the employee experiences another qualifying event. The rate of pay for the sick leave is the employer's regular rate of pay. If an employee is taking paid sick leave for use described in bullet points 4, 5, or 6, the employee's pay entitlement is reduced to 2/3 of their rate of pay. Importantly, the PSLA limits the amount the employer is required to pay to an employee each day consistent with tax credits under the FFCRA as follows, which is $511 per day, or $5,110 in aggregate, or $200 per day, or $2,000 in aggregate. Employers may not retaliate or against or terminate an employee for taking leave under the PSLA. Employers may not require employees to exhaust their current sick leave before leave using the leave under the PSLA. This means that the paid leave provided under PSLA must be provided in addition to any other paid leave the employer is already obligated to provide the employee by law and agreement. The DOL has made it clear that any paid leave provided by an employer prior to April 1st, 2020's effective date will not count toward the PSLA leave entitlement and will not be eligible for the tax credit summarized below. The EFMLA expands leave under the FMLA to provide leave for employees who need to care for their child due to the closure of schools and child care facilities as a result of the COVID-19 public health emergency. Under the EFMLA, both full-time and part-time employees who have worked for their employer for at least 30 calendar days will be entitled to take up to 12 weeks of job-protected leave for a qualifying need related to the public health emergency. Under the EFMLA, the first 2 weeks of such FMLA may be unpaid. After the 2 weeks of unpaid leave, employers must provide up to 10 weeks of paid FMLA leave at the rate of no less than 2/3 of the employee's regular rate of pay. The EFMLA caps the paid leave entitlement at $200 per day or $10,000 in aggregate. As with the traditional FMLA leave, this leave is job protected, meaning the employer must return the employee to the same or equivalent position upon their return to work. The EFMLA contemplates this exception for requirement for employers with less than 25 employees if the position does not exist after the FMLA leave due to an economic downturn or other operating conditions that affect employment caused by a public health emergency during the period of leave. The FFCRA provides tax credits for employers for a portion of the payroll taxes or for wages paid to employees taking their either paid sick leave or pursuant to the FMLA or the FFCRA. The amount of tax credits qualified for family leave wages for each employee is $200 per day or $10,000 in aggregate. The tax credits are also available for certain qualified health plan expenses related to the leave provided under FFCRA. The FFCRA has provided the Secretary of Labor the authority to exempt small businesses with fewer than 50 employees from the requirements when the imposition of such requirements would jeopardize the vitality of the business as a whole going forward. Notably, it does not appear that simply having employment population of less than 50 will relieve an employer of the obligations under the FFCRA. Well, there you have it. I know this is helping our clients already, and I hope this will help you too. If you have any thoughts or comments or questions, please place them in the comment section below. If you have found this video informative and helpful, please like it by tapping the thumbs up button. My contact information, as well as the links to this video, are located below. I will be adding content regularly going forward. If you want to learn more, please subscribe. Thanks for listening. Stay safe and healthy. Namaste, and God bless.